In very passionate and strong emotive language, you spoke about the personal issues and problems you have. They may be broader than that, that you have with the preamble, particularly the acknowledging the need to secure the advancement. You said that the Constitution should be, in a sense, an immovable document, and that recognises, in a sense, systematises failure. Do you believe, Ian, from your political experience, that that acknowledgement makes the constitutional amendments more or less politically feasible? You've spoken about your personal view. Now cast your eye over the political landscape.
I think those last two dot points of the 51A amendment actually make it more politically feasible to get up, because that's where everyone's at. It's where it's comfortable. It's what we understand the world to be. Blackfellas are at the bottom of the pile. We've got to help them up. I think that would help it get over the line. But it's not aspirational. It's a fix to a policy conundrum we have now. It doesn't reach to the highest bar. What it does is dumb things down to where we're at. And in my view, trying to say we can do better than this might be more politically hard to get up, but I think it would give us a greater value in the long term. Long after you and I are, buried and pushing daisies uphill, as it were, what will our children and our grandchildren say about us if the best we could do was say these people were entrenched and they were never going to get out of it? I think that would be harder I think it would be harder to not recognise it, because so many people are passionate about doing something about this now, and it's always the Constitution which will fix it. That, I think, is part of the political reality. But, as I said, I want to try to reach a higher bar. That's how I do it, and I'd like to see that worked out, over the next 5, 6, 7 years.
Well, as a corollary of that, we know that the panel rejected as politically infeasible, for the time being at least, any constitutional recognition of the sovereign status of Aboriginal and Torres Strait Islander people. Is that where you believe we should be pitching the vision, a discussion, a debate, as you say, blood on the floor about these very important issues for a number of Aboriginal communities?
Yeah. What's the end game we want this to look like? What do we really want this to be in the long term? Not what do we want now, what do we want in the long term? And then how do we get there? Or here's where we really think we should be, and then let those who want to argue it back and pull it somewhere in the middle. If we start off with this, there'll be those, this is quite a moderate proposal. So we're starting in the middle. And then there'll be those who want to pull it back even further. And that, I think, is part of the political problem with this getting up, is this leaves no room for a lot of people to go. For those who are in the left, who are in the, Aboriginal sovereignty and all that, does this speak to them? Will they have a buy-in in this debate? Will they be trying to pull it back further? For those who are on the other side of it, who say we're all equal and we should be treated the same and there's no difference and Aboriginal people shouldn't have any recognition, this document is kind of halfway to where they want to be. Hell, it's buried in section 51A, it's not up the front. It doesn't speak of sovereignty, it's kind of there. I think the political process hasn't been allowed to happen. You may have the political process and it comes out like this. At least then everyone has ownership of it. At least then everyone feels they have a buy-in to it. And I can sense that Mark's got something he really wants to say.
Mark is jumping out of his skin to make comment on what Ian's been discussing.
And I suppose this is the most difficult aspect of what do we want as engagement points as Aboriginal and Torres Strait Islander people. But again, just to revisit where the expert panel, the parameters in which it had to work, it had very clear terms of reference, and one of them, number one, was A, it had to have a likelihood of success. Number two, it had to be legally achievable. So all the legal terms, and the way the Constitution is actually set out is that we do have separation of powers, so big tick for you on that. The other thing is that Section 51 is the legislative powers, that's where all the legislative powers of the Commonwealth, bar a few, are contained. So it's a mechanical, why it's situated in 51 is that's the mechanics of the Constitution. Now, the other thing too is that 1967 was an absolute minimalist approach, and that was the way they got the political sell up. So when we have a history in Australia of using, and we talk about 1967 as pretty much the only social reform of the Constitution since Federation, but there is a problem that because it was seen to be so gigantic, when in fact the way it was sold to the Australian people, the majority of the voters, was that it's a minimalist approach by just striking out the words. And by taking that minimalist political approach to get it up, for the sake of getting up, has led to the freaking disaster that it's become. Because there wasn't that, let's be bold, let's put out there quite dramatically where the parameters are. So if we try to say, well, where's the political cell, you know, we've got to be very, very clear about who is saying what and for what purpose. And the expert panel just was that. It had a task to do. It was to get the conversation going. And I think, you know, so I think we're saying the same thing where it puts it, but it also needs to be a bit of where do we actually start to say where is this achievable? And preambulally, I don't agree, because there's a reason the preamble only exists to basically advise the legislature and the courts as to what the purpose of the Act was. And we have seen quite cataclysmically in New South Wales and Victoria where you have preambular recognition for no purpose other than to raise the hopes of Indigenous people in those jurisdictions, but it also lets white people off the hook. So I think, you know, these are discussion points and to move forward. So we're saying the same thing, brother.
Yeah. I guess for me what's missing in this was, and this is a question that we face as a nation all the time, where's the leadership of our nation? Where are the people advocating for this from a heartfelt perspective? Not what's practical and doable, because there's lots of people that do that. Hell, I work in the public service, and there's lots of practicable and doable people. But where are those who seek to inspire? Where are those who seek to carve out a future that gives us a hope that we leave a better world than the one we came into? That's what we need in this debate. That's what we need. That's what we need as a way forward, as a path forward. We don't have that at the moment. And that's why we've got what we've got. As I said, I wouldn't stand in the way of this because, geez, it's a shitload better than what we don't have at the moment. But there's a bit of me which is disappointed that we could have done so much better if we had leadership, real leadership, that wanted to find a greater path. And that I'm
the
disappointed
answer to that
about.
is, of course, that we would also need real political leadership from politicians
to as well.
Actually behave
as
leaders.
humanists
and as leaders, not as electoral animals. And unfortunately, how we got to having such a panel was a combination of electoral pressures on a government that was forming, and that's also what's causing us a pinch now, because that's all kind of tenuous, and so our great leaders are not really leading, they're just kind of hanging on with those fingernails.
They're moving the machine along.
So it takes leadership that's not going to be reliant on parliamentary politicians, because they're not necessarily the best people to inspire us at this point. Or they might have been in the past, or they could be in the future, but maybe not this bunch. So that leadership has to come from people power.
I was going to ask if Melissa can't go without actually answering a question. So
Yes, I can.
both Mark and Ian said from their perspective that they're absolutely opposed to symbolism, it's tokenism. From your perspective as an international human rights lawyer, cognisant of the various conventions and the like, do you believe that the proposed amendments do have practical significance, or are they simply symbolism? And if they are symbolism, is that important in any event?
So symbolism is important, but it's not enough. So symbolism is your first step, right? And I think it's important, but practical outcomes are very important.
And do these changes lead to those
outcomes? Some do and some don't. Protecting us against racial discrimination, in all federal, state laws, territory laws, there are protections for racial discrimination. It's just that it's not constitutionally entrenched. And so when a government decides to do something racist, when the federal government decides to do something racist, it's actually allowed to. And that's something that I don't think we should sit with any longer.
And this will avoid that.
And this is a way of of cutting that capacity off, which is why there's a tension in the political leadership, because they're just going to have to cut off something that they actually have expressed the need to use. Also, it would bring us into compliance with international standards that we've signed on to 30 years ago, and we walk around the world talking about what good international citizens we are, but we're not playing the game at home. So I think that it both would be symbolic change, but would also be a very practical, pragmatic change, because it would stop the government from enacting racist legislation that it deems appropriate, but the beneficiaries, I'm saying that in a very, very loaded way, the recipients of that legislation don't want that legislation to work in that way. We can talk about that another day as to whether they do or don't, but this would stop it if people didn't consent. So I think it can be highly practical. Some other bits, I mean, we can delete section 25, no one's going to know or care.
Yeah,
it's never had any effect, no one uses it, that's fine. So that's purely symbolic, but it's a really racist looking provision. So that's, but you know, it does something. So you can go through them and you can analyse them, but the anti-racism clause, if you want to call it, or the non-discrimination clause, is an important standard that we assert we comply with, but we don't really.
Was there any aspect of the proposed amendments that are inconsistent with international human rights standards, Melissa? I mean, after all, we're in a sense retrofitting into a very old document a number of very innovative standards of international importance. Is there a crash going on in there?
There's not a crash going on in what's suggested, in what's omitted. What we omitted, or what the panel omitted, what the panel omitted, it means that they haven't quite come up to standard of what the Declaration on the Rights of Indigenous Peoples would expect, or the CERD, the Convention on Elimination
What are some
Discrimination.
What are some of the important
Things
omissions?
like the standard that things that are done by governments to Indigenous people instead of with Indigenous people. So there's a standard that's called free, prior, informed consent, and that every time things are happening in the Indigenous community, that community has to properly consent. That's not the old style of stand on the 44-gallon drum and say, move on, the machines are coming in. I'm talking about real consent on the terms of the Indigenous community. I would like our Constitution to embed and reflect free, prior, informed consent, but that's not something that they were able to come at under the terms of the current terms of reference, but that would bring us into compliance with the Declaration.
And I think that we have to, constitutionally, since 1975, Australia signed on to the Convention on the Elimination of All Forms of Racial Discrimination in 1966. It was implemented in Australia through our constitutional mechanisms in 1975. It was the Racial Discrimination Act is what we used when we went after Andrew Bolt. And it has particular resonance in our constitutional arrangements. But who's heard of the Kawada case? It's just been 30 years since John Kawada ultimately won, but lost everything, and our constitution has been littered with Aboriginal issues being at these flashpoints of trying to sort out the constitutional arrangements. The race's power had never been used up until they were used on Aboriginal people post-67. The race's power has been, in my view, quite distorted since the Hindmarsh Island Bridge case, again around Aboriginal issues. But it's also, we use these instruments, CERD being one of them, but Melissa, you talked about the ICCPR and what self-determination meant. I mean, the biggest sticking point with the International Covenant on Civil and Political Rights was the concept of self-determination, whether it applied to individuals or collectives, aka peoples. Again, I keep going back to putting the S on things here matters, because it was that leap. And as we've morphed into the Declaration on the Rights of Indigenous People, and Australia's Aboriginal people were largely responsible for driving that forward, particularly Les Mauser in conjunction with others, Jim and I are from the US, Daly Sambu Doro from Alaska, all native peoples. But it's the Declaration and the way that it will find its way into Australia constitutionally that Aboriginal people in Australia know what self-determination means. So you go back to the concept of sovereignty. We don't need a document to say we're sovereign. These conceptions are already existing within our Aboriginal nations, and it is this voice of international law that we are now using to exploit and to further articulate where those boundaries lie, not outwards looking in, but or outwards looking in, but the other way around. So international law, and the way that you've described it, has been extraordinarily important in the way that Aboriginal Australians have actually exercised our own views under the constitutional arrangements and have used it quite strongly against recalcitrant states, dare I say it, Queensland, you buggers. But it's important to actually keep all this in context, because all of these issues that we say are so disparate that don't come together, they actually do. International law and the way it's played out in the Constitution, our own concepts of sovereignty, and the way that that plays out and has our voice is really important understanding. So these measures actually are going a long way to further that discussion. But I really rally against, we don't need non-Indigenous people to say that we have sovereignty and self-determination. That exists, and that is just a bedrock, and I'm over that ridiculous conversation. Sorry?
No, sorry.
I was on a roll there. But anyway, I think all these disparate things are coming together, and it's how. But unfortunately, though, Ian, it's up to us as Aboriginal people to educate the broader ones as to how it all works together, which is kind of antithetical to this whole movement. But I think that really is trying to say, well, what do we understand it? And I think now is the time that most Australians are receptive to our worldviews and how we all fit together. But yeah, we're all bringing it together.